All rise. The Court of Appeals Division 1 is now in session.
Good morning, and please be seated. This is the time set for oral argument in Thomas v. Greystar, our cause number 1CACV20-0662. Counsel are familiar with the procedures of the court. Each side has 20 minutes, and the appellant is responsible for reserving as much rebuttal time as you're able. With that, if you'd like to proceed.
May it please the court, my name is David Abney. I'm here today with my colleague and friend Chris Koppel. Before I start, I want to mention that I had a shower this morning. And I don't mention this for personal hygiene purposes, but I got water in my ear, and I have this left ear is like it's no good. I've Q-tipped it and everything humanly possible except vacuum it, and I don't know what's going on. But
you don't have to worry about that since I'm on your left side.
Okay, all right. Well, with a little bit of luck, this will go okay. It's something I don't have any control over, which brings me to my first issue I'd like to discuss is control. The landowner's control over the property. My colleague says, well, we didn't have any control of their property because we hired a management company. But there's nothing in the record that says the landowner lost control over the property, right of possession, right to say what goes on there. So, which leads me then into the Welker doctrine.
Well, is that the test, though?
Pardon me, Your Honor?
Is it that general, whether they have control over the property, or is it more focused?
I think it's general, unless there's something in the record to say that they have given away some sort of specific item of control. But here, there's nothing like that. Just because you hire a management company doesn't mean that you lost possession or control over your property. It's your property.
So what's the evidence in the record to I guess fall under that theory that I guess is it Litchfield retained? You're saying Litchfield retained control, and you're saying it's over generally the entire apartment complex and not what's being worked on, I guess?
Sure. Well, what matters is what's being worked on. The general rule, if you start talking about roofs, the general rule is that roofs are considered to be common area property, which is under the possession and control of the owner of the property. But there's nothing in the record, as I said, that says that they lost control over any part of the property. It's their property. They own it. I suppose you could make an argument that people that have individual apartments and whatnot, that the control is greatly attenuated, but that's not the issue here.
But is any of this the issue here? Isn't the issue here what the employment arrangement was and what the consequences of workers' comp are?
For the management company, that's an important issue. But for the landowner, the issue is really a Welker problem. If you retain possession and control over the property, then you fall within the Welker doctrine. And if you know or have reason to know that there is some sort of danger to the property, that an invitee coming onto the property, such as the worker here, doesn't know about or may not discover, then you have a duty to warn about it and to take steps to correct it.
Well, that may be true, but again, we're talking about preemption under workers' comp, and the question really, I think, is what the employment relationship was with all three entities.
No, because the landowner, there's no contract between the landowner and that I'm aware of, and the immediate employer of...
Not the immediate employer, but the immediate employer was essentially a temp agency, for lack of a better term, right?
Right.
Okay. And then the management company hires the temp agency, and the owner hires the management company. The question, I think, is that you have to address first to see whether there's even a jurisdictional basis for your claim, is whether the relationship between those entities and the employment of Mr. Thomas implicates workers' comp with respect to all three.
I think that's a great issue, but there is a break here, though. The employer, if there is a special employment relationship or land employer or whatnot, it's Greystar that would be the supposed employer. It's nothing to do with the owner of the property. The owner of the property is simply retained, not as an employee, is simply hired a management company to take care of managing the property. So there's no employer-employee relationship between Litchfield and Greystar. It's simply they hired somebody to be in charge of managing the property and make sure it's in good repair and good condition and kept up. That's all that
But
is.
If BG staffing had contracted with CB staffing, which had contracted with AD staffing to hire Mr. Thomas, would we look at all three of them as employers, or would we say, well, no, the contract only exists at one level?
I don't know. I don't think you would, but that's a sort of that's standing on my feet answer. I'm not quite sure.
It just seems to me that we see all the time that there are subcontract relationships that result in employees working on a job site, but actually seeing the economics of the arrangement flow through a number of entities. I don't think that defeats the workers' comp bar. And so that's my first concern, is not really tort law, but subject matter jurisdiction.
Well, as far as Greystar, if Greystar were considered to be the special employer, you'd have a big problem with this workers' compensation immunity. Mm-hmm. But it has nothing to do with the owner of the property. The owner of the property is not.
Why is that?
They don't have any workers' compensation coverage. They don't buy it. They simply own the property. They hire a management company, so there is no workers' compensation immunity. They don't provide it.
Of course they provide it. They're hiring the management company. The economic resources for the workers' comp coverage is coming from the ultimate payor, and that's why they do it, right? I mean, you don't hire a management company who hires an employment agency who hires an employee to expand your liability.
I think that's a bridge too far. Just because they happen to be providing money that's going to be used to buy who knows what, including workers' compensation coverage, doesn't mean that the owner of the property is in any way a supplier of workers' compensation coverage or somebody who pays for workers' compensation coverage.
I'm not saying that they're directly the supplier, but when you say they don't have workers' compensation coverage, what they have is an independent contracting relationship with another entity that has workers' compensation coverage.
Right. And so for Greystar, then the issue with Greystar is there this employee relationship or not, which deals, of course, with who controls.
Before you get to that, can I just, one more thing on what record in the evidence was there that Litchfield knew this carport was in bad condition?
No, I don't think there's much at all, other than some reports that have come in about, roofs, various roofs needing cleaning up, that sort of thing. But remember, they have a positive duty, though, as the owner of the property, not just to sit there and say, well, we don't know anything, we never knew anything, sort of the Nuremberg defense. They have a positive duty to go out and find out the condition of the property. And the condition of these roofs was apparently horrendously bad. It was so bad that Thomas himself was a bit concerned about it. He made no bones about it. He was worried about the roofs collapsing. He wasn't worried about making a false step. He was worried about the roofs collapsing. And so there was some concern about that, but it's what you know or should know as the owner of the property that matters, and that's a jury question. What should you have known? Knowledge. When you start talking about knowledge, you're into jury questions.
What was the evidence that they should have known? That was in the record.
Well, from it comes from Thomas himself. The deplorable condition of the roofs, even the property manager testified that there was a great deal of accumulation on the roofs, and he said, well, I told Thomas, don't go on the roofs. The inference being, if you go on the roofs, it's a bad thing because something bad is going to happen getting on these roofs.
Who said don't go on the roofs to Thomas?
The property manager. That's their testimony.
But not Litchfield.
No.
Okay. And that's who I'm talking about.
Well, Litchfield, to get to Litchfield knowledge or should know, you've got a jury question. The jurors could say, well, look, this stuff's been on the roof.
Right.
Thomas testified.
We don't have knowledge, right? You said there's no evidence of knowledge.
Not that kind of direct knowledge, other than should know from the condition of the roof.
If you're going to get there, it's got to be under should know.
Yes, and, of course, the knowledge of the agent is computed to the principal. And we know that the management of the property knew that there was a problem with the roofs and all the debris and whatnot because they hired and asked Thomas to go up there and fix the problem, which, according to Thomas, was a major endeavor.
Right, to clean, right? Wasn't that the...
To get the debris off the roof. Debris that was so heavily accumulated that Thomas was worried the roofs were going to collapse. And all this knowledge, of course, that is in the record with the management company is imputed to the owner of the property because the management company is the agent for the principal. And what the agent knows, the principal knows.
can go to Greystar.
Okay. Which leads me back to the Welker Doctrine as far as the landowner. A fascinating case, and I've read it and I've talked about it in other situations and in other cases, and every time I read it, I find something new. And you go through the procedural history of it. There was a jury trial in the Welker case, and the jury could not reach a decision. So after that happened, there was a mistrial. Kennecott moved for a judgment. It looks like a judgment as a matter of law, and prevailed on liability. Then it goes up to the Court of Appeals, and the Court of Appeals does one of the best dissertations on the law of liability in this sort of situation, and ends up, in the end, remanding back for a new trial so that Welker's survivors can try to develop the case further. But the important thing about Welker is that no matter what else you talk about, if you have a situation where there can be liability if you turn over, but in order to have non-liability, you have to turn over safe premises. And these premises, we submit to you, were not safe.
So let me take you back. Doesn't the restatement there, you had just said that Thomas, I think you were using Thomas's
Right.
testimony as the basis to show it was unsafe. But doesn't restatement section 343 say that in this case Thomas must not have been able to discover or fail to protect himself against that danger?
Yes. Let me see if I got the language
So
right.
how does that not defeat the argument?
Okay, so the possessor is liable if he knows or by exercise of reasonable care would discover the condition, it's an unreasonable risk of harm, should expect that the invitees will not discover or realize the danger or will fail to protect themselves against it. It's a disjunctive.
You're using the plaintiff here
Right.
as the evidentiary hook to
Correct.
show that it was dangerous, but that
In
it's
part.
based on the other on the restatement section 343.
Well, the danger that Thomas perceived was that there was a large accumulation of debris, and he was worried that the roof would collapse, and that's not what happened. What happened was he was told to go to work on this beam area, which he did this is the third day he's doing this project. He's doing it successfully for 2 and some part of a day, and then apparently gets away from that beam area and right through the roof. But the roof doesn't collapse. He falls right through it. And the question is, and this is a disjunctive problem, expect that they will not discover or realize the danger. Reasonable jurors could say, well, he knew there was a problem, but he just didn't realize the extent of this danger. He didn't realize what the problem was, or will fail to protect himself against it.
But Mr. Abbey, I'm still lost on it, been listening to what you're saying, but the roofs, there's nothing in this record, is there, that would indicate the roofs were dangerous. The danger was walking on the roofs, right? If you're the landowner, you're not thinking my roofs are going to collapse.
Okay.
You're thinking, oh, God forbid somebody should get up on that roof and walk around because they might fall through it.
I
But
think
that's not what the landowner is thinking. He's thinking, oh, there's a roof.
I don't know exactly what the landowner is thinking. I think a reasonable jurors could infer the landowner knew or should have known that there's a problem with the roofs. Even the property manager is saying, don't go up on the roof, although Thomas says they told him to get up on the roof.
But that's inherently what Thomas is doing, not the roof itself. The roof itself was okay for its purpose,
Well,
right?
it's okay for its purpose of keeping rain, debris, and junk off whatever's below it, sure. That seems to be true, but there's...
It wasn't a collapse. You just said the roof did not collapse.
Right, but reasonable jurors could infer from what happened and from the directive to walk only in the beam area.
Which is not the landowner. The landowner did not direct.
No,
There's
landowner didn't
nothing
do
in
that.
this evidence that would indicate the landowner directed.
Landowner's
Get up on the
agent
roof.
directed that, but the landowner didn't do it. The thing about the landowner is whether he knew or should have known that this was a dangerous situation. That's a jury question. You also have a
And what
question.
should the landowner have done? Let's say the landowner said, wow, these roofs are really weak. I assume the answer is they should be fixed, right?
Reinforce the roofs or get a cherry picker.
Okay. Now,
Something to elevate somebody that they don't go on the roof to clean it.
wasn't Mr. Thomas's work the first step in doing that? I mean,
No. And reinforcing the
And
roof?
taking the debris off the roof, isn't that the first thing that one would normally do? Now, I'm getting into negligence, and that's really not where I wanted to take you, but because these other questions have been asked, I'm still trying to determine, from Litchfield's perspective, what was the negligence?
Well, the negligence was, and as a landowner, you know or should know there's a problem. Your duty is to protect against that problem. One of the ways of doing that is to provide an adequate warning. And Thomas wasn't given an adequate warning. All he was saying is to work on the beam.
Signs that said, "Do not walk" on the carport roof.
They didn't tell him that. What they said was...
No, wait a minute, back up. You said earlier that the reason why we're going to impose liability on this landowner is because the landowner was going to turn over these premises in unsafe conditions.
Correct.
Right.
Yeah.
But you haven't told me where it was unsafe. It's only unsafe if you're walking on it, which is not the purpose of the roof. The purpose of that roof is not to walk on it.
No, but in order to clean the roof, the property manager told him, you can do this. This is the way we do it. You walk on the beam. Everything's fine. You walk on the beam. And for 2+ days, he walks on the beam and everything's fine. Then apparently makes a misstep and right to the ground, and he's badly hurt. So there are so many jury questions here about know, should have known, knowledge, whatnot.
Before we get
this
to
is
the
not
jury,
something a judge can resolve.
Before we start calling jurors in, let's talk about subject matter jurisdiction one more time, because I want to give you a chance to respond to something. In your reply brief, you cite Lee versus M&H. Okay, and you cite it for a proposition that I think is fairly non-controversial and helpful to you. But Lee versus M&H pretty clearly immunizes, and that actually is the right word given that we're talking about subject matter jurisdiction, immunizes landowners for liability stemming from the negligent conduct of a subcontractor. And it seems to me that your allegation here really is this guy shouldn't have been up on the roof.
Right.
That there should have been a cherry picker involved or some other way of dealing with this roof. Otherwise, you're truly in the no good deed goes unpunished land, because when a landlord or landowner sees, I've got a problem with my land, let me hire somebody to deal with it, how can you say that's negligent? And how can you say that Lee versus M&H doesn't kill your claim with regard at least to Litchfield?
Because Welker and Robinson and all the other cases that follow Welker, including cases from 2021 from the Arizona Supreme Court, all say Welker applies. So if we're talking about landowner liability, if you've retained control and possession of the premises, and you know or should know there's a dangerous condition there, and you know or should know that the invitee coming on there may not realize the extent of the danger, then you can be liable. These are all jury questions, though.
Well, it's funny you mentioned Welker, because that's exactly the case that Lee versus M&H cites for the proposition that I just gave you. But we're still in the position that you've got this employment relationship and independent contractor relationship wending through these three entities, and you have a doctrine that immunizes landowners from liability for employees of subcontractors. I'm struggling to see in the land of workers' compensation how there is subject matter jurisdiction even to call a jury in.
Because as what Welker itself calls the rule of what do they call that? The rule of non-liability has the exception that if you turn over unsafe premises to the invitee, and you know or should know that they are unsafe, and you know or should know that the invitee will not take steps to protect himself because doesn't realize the full extent of the danger, then there can be liability under Welker, which is one reason Welker got remanded to the trial court for further proceedings and wasn't just up at the judicial level taken care of. There are so many issues of fact here about whether Welker applies or not that I believe Welker does apply, Your Honor.
Okay.
I'll reserve my whatever time it is.
1
Thank
minute
you.
and 24 seconds.
Oh, I thought 125 for sure. Thank you, Your Honor.
We'll throw in an extra second.
Good morning, Your Honors. Can you all see me?
Indeed.
Wonderful. I'm Jennifer Rebholz. I'm on behalf of the appellees, and this is Taylor Allen. I'm going to start by talking about Greystar and kind of talking about this workers' comp arguments that you guys were talking about. And I think Lee really is the appropriate case in this instance. There are 3 elements to essentially determine if you have a lent employee. And in this case, all 3 of those are met. The first is that you have a contract for hire, whether it's implied or an actual contract, but in this case, we have an implied contract. He shows up, he goes to work every single day. You have the work that's being done is especially the work of the special employer, which again is Greystar. He's showing up, he's doing maintenance work. The record's clear. He's painting basketball hoops, he's fire hydrants, picking up dog poop, cleaning up the property. He's doing property management kind of material or things. And finally, Greystar controlled the details of his work. They told him what to go do. We need you to go paint this. We need you to pick this up. We need you to go clean off the roof. In the appellant's arguments, they kind of point to, hey, there's this argument over whether or not they told him to get up on the roof. Thus, Greystar is claiming that they weren't controlling what he was doing, and that's not really correct. They agreed that they were telling him what to do. There's a disagreement over how they told him how to do that, but that's not a disagreement over the fact that they were controlling the work he was doing and telling him how to do that. Whether or not there's a factual dispute over what was said doesn't change the fact that they were controlling his work. Because all three of those elements were met, you have a lent employee, and thus Greystar is immune from a tort case here that should go through workers' compensation. And interestingly enough, it did. He went through workers' compensation, and he got paid through that. There was some conversation about Litchfield and whether or not that applied to them as well, and we would argue that it did. And actually, there is evidence, and if you look at the contract that's part of the record in this case, Litchfield does specifically pay for a portion of the workers' comp coverage in this case. So again, that's the idea that we hire this independent contractor, we're paying for all of this, we should be covered underneath it. There was discussion over whether or not the Welker Doctrine or Lee or any of these other cases somehow had an exception, so thus Litchfield is going to have some liability in this case. This court has looked at that over and over again, and I think there is some confusion over what we're talking about. Again, it seems pretty clear based on Welker that if you turn over control of a property and it's a safe property, that you don't have any other duty. You wouldn't have a duty you would normally had to just a third-party person coming in here. And in this case, that's exactly what happened. This court actually recently, just in March, had a very similar case, Scott versus a Catholic church. And again, it was one of those where, and I think you were talking about it earlier, Your Honor, that it really did kind of narrow the issue. It's not, did we have control of the entire property? It was, did we have control of the space where the work was being done? In that Scott case, it was, again, kind of HVAC. They were in the attic breezeway area. And it was a very similar situation where they were saying, hey, there was this unreasonable risk because somebody's walking across this beam and maybe it's not the safest thing in the world. And the court in that case said that's not unreasonable. You're hiring people to go up there and to essentially repair or to clean this area. Could the independent contractor have done something different? Yes. But the law specifically says that Litchfield, the property owner, is not liable for the negligence of Greystar, if there was negligence of Greystar in this case. So, again, I think that case is really controlling here. Litchfield did not have control of the property. Litchfield did not have control over what they were doing. They should be covered by workers' comp anyway, but none of these exceptions seem to apply. I'm happy to answer any questions if anybody has any.
Sounds like there are none.
Okay.
Thank you.
Thank you, Your Honors.
Well, looks like I don't need to put more change in the parking meter. My colleague says if you turn over control of the property, which is really one of the big problems here, there's no evidence of any turning over of control of the property. So as far as the property owner is concerned, we fall into the Welker situation and the cases that have followed Welker. I think I've made my best pitch, and eloquent as it is, and I'm willing to concede my remaining seconds to the court.
Your presentation contained no lack of eloquence, and we appreciate it. If there are no further comments, then we will deem the matter under advisement. We'll issue a written decision in due course, and the court will stand adjourned.
Thank you, Your Honor.